You know, the fact that you can't find anything wrong is no reason to offer a subpoena. I yield back.
Pursuant to the unanimous consent, the gentleman from South Carolina, Mr. Gowdy, will control the last 6 minutes.
Thank you, Mr. Chairman. I want to thank my colleagues on both sides of the aisle. I've learned a lot this morning. Mr. Chairman, I have learned that you can have a firmly rooted constitutional right to assert on behalf of an entity that is neither named nor contemplated by the Constitution. I previously was not aware of that. What I would like us to leave with today is some consensus on what the standard is. I just want to understand, because I honestly think there is a hunger in this country for any group to apply the same standard, the same rules, regardless of politics, regardless of which party is in power. Recess appointments should not depend upon which jersey the President has on. I think we can all agree on that. So too, the power to summon somebody before the people's house should not depend upon which party is in power. And what I have heard from my colleagues on the other side of the aisle this morning cannot possibly be the standard. The standard cannot simply be that you have to have done something wrong. We don't have the power to investigate criminal conduct. You all know that. You remind us of that all the time. We don't have the power to investigate or prosecute criminal wrongdoing. That's another branch. So that cannot possibly be the standard. Can we summon someone before Congress to discuss good news? What if they've done a good job? Can we send them a summons? Can we invite them to come share with us the progress and the success they've had? Not under your standard. Can we invite someone to come discuss how to take their department from good to great? You're doing a good job. Let's do a great job. Can we summon them before the people's house? Not according to your standard. Can we invite them to discuss appropriations? Can we summon them to discuss policy? Not according to your standard. Your standard is you have to have done something wrong or you have to have broken a law. And y'all know that can't be right. You got really bright lawyers over there. You know that we have no power to investigate criminal wrongdoing. So how can that possibly be the standard? What is the standard going forward after today? When can this branch, when can the people's house summon people to come? Can we discuss policy? Appropriations? Good news? Can we bring them over to say you're doing a great job? Or is it only when it verges on criminal wrongdoing will you concede that we have the power? This is what is most vexing for me. And this is what I really want. I really want some of the very reasonable-minded folks on the other side of the aisle to think about. Are you really willing to concede that this branch has less power to summon than the other two branches? Because that's what I hear you saying. The judicial branch doesn't only have the power to summon people upon an allegation of wrongdoing. The executive branch doesn't only have the power to summon people. Some of you have done criminal work. You can send a grand jury subpoena to someone who's totally innocent. They just happen to have facts that you're interested in. A circuit court judge, a district court judge can send in a civil case a subpoena to someone. There's no allegation of criminal wrongdoing. You all know that. Many of you have practiced that. So why are you telling us that we have less power than the other two branches under the Constitution? What is the standard going forward after today? Can somebody explain to me? Because we all believe in bright lines. And I may live long enough one day, I don't know if I will or not, but I may live long enough to see a Republican president. So what is the standard going to be?
Gentleman yield.
What is the standard going to be?
Because
I'll tell you what I would like to do. I will in just a second, although I hasten to add your colleagues did not give you any time, and they should have because you're one of the brightest members on that side. But I may, if I have some time left, do what they were not willing to do. But I do want someone to tell me, If there's a Republican president, are you willing to apply the same standard? Are we willing to apply the same? I mean, look into your well of souls and say, at the end of this debate, is this a standard we can live with regardless of who is in power? Can we really only bring witnesses? I'm not talking about testimony. That is executive privilege. That has nothing to do with what we're talking about. It is the power to summon someone before the people's house. Is the new standard only if you have done something wrong and only if we have a hint of criminal impropriety. If that's the new standard, then let's live with it going forward. I just think you're giving short shrift to the people's house. The reality that we can't bring someone here to talk about good things they're doing or policy improvements, that we can't bring the Secretary of Agriculture before a committee of Congress to discuss something that's not wrong and not criminal. Really, you need to think about what we're doing today and whether or not you are in the short term shortening your own constitutional prerogative, because honestly, after all the morning's worth of debate, I cannot tell you what the standard is going forward. I can't do it. With that, I would yield back to the chairman.